it on Mr. Johnson when you get a chance.
I had a pen I can borrow. I forgot. I don't know. Thank you. All right. What was his name?
Mr. Johnson, Luke A. Johnson.
What are we going to do?
It needs to be a 11 months, 29 days length of probation so that we get out of the out from underneath the interstate compact. And we've all agreed that we can mail in his report. He's currently living here, but he may be returning to live with his family nearby. Mr. Johnson and his father are present.
All right. Okay, I'll modify it to that change.
Okay, thank you, Your Honor.
Is that okay?
Yes, sir, we were just trying to help him because when he came and sat down, he started talking about maybe wanting to transfer to another state. And that
All right, we'll do that then. You got that, Ms. Sam?
Yes, sir.
Okay.
Thank you, Judge.
Now we got Jeremy Dixon. All right, so what is it you're asking for, Mr. Tony?
We're asking, Your Honor, based on his 3 times a week dialysis that takes 4 hours and 15 minutes, that the court, even imposing a sentence suspended, sentence him to house arrest and probation for the remainder of the terms of the 64 months. So there'd be 2 years of community control and 3 years of probation. Also, a substance abuse evaluation as well, Your Honor.
All right, what are you asking for, Ms. Leon?
I was asking for a guideline sentence. That's what the law provides. And among the mitigating circumstances for that would justify a downward departure, the statute does not contemplate the dialysis requirement of this defendant. He was found with trafficking amount of cocaine, and the state agreed to a lesser included simply so that he would avoid the imposition of a minimum mandatory of 3 years. The state feels that, so he obtained a break at the beginning when the state agreed to sell, manufacture, deliver of drugs instead of trafficking. And now he's asking an additional benefit, and the state is very clear that statute 921.0026, mitigating circumstances, states that a downward departure from the lowest permissible sentence is prohibited unless there are circumstances or factors that would justify it. Among the factors, having to go through dialysis is not present. For the reason allowing the defendant to plead to anything, to impose a sentence to anything less than what the guidelines prescribe would be an illegal sentence. As I stated before, the Department of Correction, the prison, would provide Mr. Dixon with the medical care that he needs, including, but not limited to, taking him 3 times a week for dialysis treatment. So, additionally, probation in the PSI, after having considered all the conditions and situations of this defendant, suggests that he should be sentenced to incarceration per the guidelines.
May I respond, Your Honor? Your Honor, the benefit of the bargain here is not a restriction on any other mitigation factors that this defendant can bring before the court. The benefit of the bargain was the capping this case at 64 months with an opportunity for an open plea to Your Honor. And with regards to the statute, it is exceptionally clear. The defendant requires specialized treatment. He's in stage 5 kidney failure, right? This order, his ailment is known and was also presented in the pre-sentence investigation report. He is substantially impaired to the extent that he needs exceptional treatment. I mean, he's getting dialysis 3 times a week for 4.5 hours. His kidneys do not work. He takes substantial amount of medication in order to just even have a simple bite of food. These are factors that the court can consider in a departure because it clearly aligns itself with the statute. To that resolve, Your Honor, and he's on disability, hadn't worked in 3 or 4 years because he can't, and he lives with his 74-year-old mother who's also on disability. To that extent, Your Honor, if the court is going to impose a sentence, we simply ask that it be suspended, he be given community control, and would allow the court to monitor his activities as well, and also because of his dependency on this substance as well, he be required to have a substantive evaluation to further see if he needs any additional treatment.
Your Honor, may I make a correction? I believe that there was a misinterpretation of the statute when it comes to the specialized treatment. That is subsection D of 921-0026, which reads, the defendant requires specialized treatment for a mental disorder, not for the kidneys.
It doesn't say mental, Your Honor. It says mental, it says or substance abuse or physical disability. It doesn't just limit to just mental. And she knows that because we're both reading the same statute.
What does it say again?
The statute said the defendant requires specialized treatment for a mental disorder that is unrelated to substance abuse or addiction or for a physical disability, and the defendant is amenable to treatment. He has a kidney that does not work.
Well, I think what I'm going to do is, let's see, this is 1 count.
Yes, sir, Your Honor.
I think I'm going to adjudicate him guilty, give him a 5-year suspended sentence. It's a downward departure because of his medical condition, requires specialized treatment. Special condition, 2 years community control with 3 years probation. And
All the fees and costs associated with Your Honor.
standard fees and costs.
Could his cost of probation?
Is that 5 years suspended with 2 years community control followed by 3 years probation? That is legal.
It's fine, Your Honor, because it's a second-degree felony, so you would have jurisdiction.
Mr. Berry, did my calculation. I think I got it right. Is that correct?
That's correct.
Okay.
Your Honor, could we have the cost of supervision waived because of his disability?
Yeah. And if you mess up, you're going to be sentencing yourself to prison, Mr. Dixon, because I suspended it. So if you mess up, it's like you're sentencing yourself to prison, okay? So don't mess up, okay? Thank you.
That's all I have, Your Honor. May we excuse?
All right, Mr. Martinez. All right, this is Vicente Richard Martinez, correct?
That's correct, Your Honor.
Case number 22 CF 1379.
Yes, sir.
I have read these reports, evaluations. One's by Dr. McDonald, and the other was by Dr. Zeman. And the court feels that, based on these evaluations, that he is competent to proceed. Got a rather interesting past, but I think he's competent to proceed based on these reports, although Dr. Zeman thinks he's not quite there, but Dr. McDonald does, so I think he's competent to proceed. What do you want to do?
Judge, let's leave him. I don't think that the state's gotten subpoenas out, but we can go ahead, I guess, and put him on the docket. I know he's interested in working the case out, but I know that he's not wanting a state prison sentence.
Nobody wants a state prison sentence. I mean, you know.
Well,
But you may not get one. I don't know. See what you can do. So what about October 30th?
that is the next pretrial conference in this division.
Is that okay? Yes, sir. All right, well, get with Mr. Williams, and maybe you can get it worked out.
Thank you, sir.
Okay.
I am very grateful. Thank you, Mr. Williams, sir.
Okay. Judge, I believe that that's all the business that I have with the court.
Okay, yeah, thank you.
Your Honor, this is Mr. Washington, Amos Washington, 21 CF 2413. Tim Gibbs on his behalf, Judge. We're set for a Nelson hearing at Mr. Washington's request.
Okay, Mr. Washington, tell me what problem you have with Mr. Gibbs that you think he's ineffective.
Okay. The first one was he's lied to me about plea offers on 3 different occasions, one of which I have here in writing. The second and third time he told me about pleas right here in the courtroom. It's causing more confusion and anxiety on my family. We keep preparing for something that isn't even happening. I'm just wondering, why does he keep telling me this and it's not happening? Like, you're telling me about this offer, and then when it comes to the date and I asked about it, it's a whole different story. So that's one of the issues. I've also, every time I asked him, every time I see him, it's like we didn't even speak the time before. I asked him to provide my discovery. He hasn't provided the transcripts for all my court dates. He has not provided my property release request, copies of the character letters. I've even had people, it got to the point where I wrote character requests getting ready for the plea offers that he was telling me about, and it didn't happen. He hasn't provided the phone request records I've also requested. Third, he's advised me to sign a life sentence without even ever asking me what happened. Not once has he asked me what happened or advised me of a defense, of a possible defense, if any. I just don't see how I could go to trial with someone who is giving me instructions on doing things and hasn't even asked me about the details.
Mr. Gibbs?
So I kind of want to address a few of the things that he said, Judge. First, he's mentioned that I haven't sent any character letters. I believe there were some that I had already provided in discovery that he had provided to me. I'm trying to pull that up now to ensure that it was indeed filed in reciprocal discovery and sent to the state. There were at least 3 of them, Judge. I'm pulling those up.
Where's he on the docket today?
On the 2 o'clock docket, Judge.
Amos?
Yes.
Edwards?
Yes, sir.
Washington? Okay.
Judge, and let's see here. As far as the character letters, Judge, he had given me copies of letters from Carl Dorn, Gianni Gibson, and Ernestine Simon. Those were sent off in reciprocal discovery to the state, Ms. Sandler should have copies of those in her file. As far as phone request records, those have not been done. Property release, but I believe the property release as far as there's a locket or a piece of jewelry, necklace that belongs to the alleged victim in this case. The family is trying to seek that. Where I haven't been able to coordinate that exactly with Ms. Sandler, but that's also slowly been in the works. The plea offers he's talking about, there was a time, Judge, where I had believed that the state would have been willing to offer him 25 years as the Minuteman, which currently as charged, he has a minimum mandatory of 25 years. I was under the belief that he had potentially an offer to plead to that exactly, to receive exactly 25-year Minuteman. However, after I relayed that to him, Ms. Sandler had informed me that no, that was not an offer. The offer that had always been initially offered from the state was 25 years of a Minuteman, pleading up to the bench with that 25-year Minuteman, with the potential for life because he is charged with a life felony. The last offer that we had, Judge, was we were trying to at least get a cap, potentially at anywhere from 30 to 40 years. Ms. Sandler informed me that she was prohibited from doing that, and that her superiors, her supervisors, are requiring that she goes to trial. In this case, depositions have not been done on this case. That was something that Mr. Washington and I discussed. The main witness in this case is now 11 years old. She was 9 at the time of the incident. We were trying to avoid having to depose her, trying to avoid having her to come and potentially testify in court to save her from that trauma, from reliving that trauma. We were trying to negotiate the case. And now that we are in a situation where Ms. Sandler is being informed that she must go to trial, we're having to prepare for that trial. As far as advising him to sign a life sentence, I may very well have advised him to plead up at some point, informing him that he has a potential for a life sentence. And so that's what I wanted to address, Judge.
When I asked him about like the different offers, he just told me he heard it wrong. Maybe he heard it wrong. That was his explanation to me.
Well, the state sometimes in difficult cases like this, Mr. Washington, they do make several different type of offers, and they have their supervisors that they are willing to maybe do something, and their supervisor says, no, you can't. And, so the defense attorneys can only, none of those offers mean anything until you accept it. You don't have to accept any offers. Mr. Gibbs, it sounds like, is just doing his best to give you different options based on whatever the state is telling him or offering.
It's just confusing. He's confusing.
I understand, but no one's forcing you to enter a plea. You have every right to go to trial. You have every right to remain silent. You have every right to see your discovery. Mr. Gibbs, he's provided discovery to?
I'm certainly, currently we're on the 27th amended discovery exhibit. I'm happy to start compiling that and sending to him. My caution, of course, would be that because of the nature of his charge, that he keep it very safe.
Yeah,
Of course.
part of the problem is, see, what happens a lot of times, defense attorneys, when you're facing these kind of charges, until you really know they're going to be preparing for trial, a lot of times they'll keep them so that other inmates don't see your discovery in jail and then testify against you and say you confessed to them. You see, isn't that right, Mr. Gibbs?
Yes, Judge, indeed. And we have spoken about me bringing body cam to him for him to see, as well as any other pictures or photographs, excluding potentially the scene in case he does not want to see those.
I want the whole thing.
But he wants to see everything. I've spoken to my investigator
Sounds
about
like
doing
Mr.
that.
Gibbs is getting it all together.
Yeah.
And get it all, everything to him. And you got it, Mr. Washington, let me tell you, when you get this discovery, you've got to be careful with it.
I know that.
Because other inmates, you may think that they're your buddy, or they'll read it and say, you confess to them, so that they can get. That's what Mr. Gibbs is trying to watch out for.
I understand that.
I was a prosecutor and defense attorney, but I used to always tell my clients, look, I'm going to give you all this discovery, but you got to keep it close, because almost every case, somebody comes up and they got into the discovery and said that you told, or that my client or whoever it was confessed. So that's what's going. You got to try it. But Mr. Gibbs, give him everything. So if that's what he wants.
I just feel like since I said basically that I wanted to avoid a trial, he kind of interpreted it in a way of, okay, well, you're all the way guilty then.
No.
Instead of
It-
like that, I don't want to fight for myself at all.
He's fully going to get prepared if he's not already for trial, and you have every right to go to trial or enter a plea, whatever you want to do. No one's forcing you to do anything, but you got to go one way or the other. Mr. Gibbs, get that to him. I find you're not ineffective at this point. I'm not relieving you. Mr. Washington, he's going to get that discovery for you, and then he's going to get there and go over it with you, and keep it secure, okay? Thank you.
And I already did let Dave know to start trying.
Bring that action.
Do we have this gentleman? Who's this gentleman? I can't see very well. Who is it?
Cash, last name Cash.
Cash? You had the car problem or something?
Yes, sir.
Come on up. When you have a problem, you got to call your attorney. Don't call the judge looking for help, because judges don't help anybody.
Yes, sir.
Okay, let's see. What was your full name?
Gregory Cash.
Is he on the arraignment?
It's a VOP, Your Honor. I'm pulling up the records.
Did I issue a capias for him?
No, I don't believe so. No, it wasn't called. So,
He got he's here on a VOP, correct? Arraignment?
yes, Your Honor, and I have an offer
What is it?
to admit the VOP and modify probation, extend 6 months, count 1 and 2 to complete all the requirements. So basically reinstate and extend 6 months.
You want to do that?
Yes, sir.
What's your full name again?
Gregory Cash.
What's his case number?
It's number 22CF1548.
All right, you're Gregory Cash. You want to enter an admission to violation of probation, correct?
This is going to give me an opportunity to correct it, to get...
Yes, I'm going to put you back on the original terms of probation, extend it 6 months.
Okay. Yes, sir.
You want to do that?
That gives me a chance to complete everything. Yes, sir.
But you got 6 more months of probation you got to do.
Yes, sir.
Would you raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God?
Yes, sir.
You want to admit that you violated probation?
Can I ask a question?
You want to admit that you violated probation?
Well, if I do and I still complete it in 6 months, will I lose my rights? If I admit that,
Lose your rights. Whatever you were convicted of, if you were convicted of anything, you may have been withheld adjudication. I don't
Yes,
know.
sir. Yes, sir.
I'm not going to adjudicate you. I'm just going to put you back on whatever you were on with 6 extra months.
Okay. Yes, sir.
Whatever rights you lost, they're still lost. But I'm not doing anything different that will create new loss of rights. You understand?
I guess my question is, if I complete this, when I do the 6 months, is there a chance I can get my right to vote back, my right to bear arms, to own a gun?
Probably not. I don't know. I don't know what I'm going to appoint a public defender to represent you, and we'll set him down for, you're going to get to come back. If you can get it resolved, we'll set him for October 26th. If you can get it resolved, come back sooner. There's the public defenders. They can answer those questions. I can't advise you that.
Okay.
Just when you're in criminal court, think in terms of you kind of lose things.
Right. Yes, sir. I
Rights,
understand.
okay? But I hope you don't, but public defenders appointed, they'll represent you and tell you what you got.
Okay. Thank
Okay.
you. Yes, sir.
Make sure your transportation's correct next time. It could be a capias. Mr. Phelan?
Yes, Your Honor. We were in court just the other day, and then yesterday I got a letter from him that said that he wanted to speak to the judge on the 28th.
Oh, yeah, if you got the mental health court going, that's fine.
Yeah. So
Yeah,
that's why I brought you here, so
Oh,
you
okay.
could say whatever you wanted to say.
Yeah, yeah. We're waiting for mental health court for how long? Because if this can be wrapped up, there's no need to,
I
ask
don't, I
for
can't.
another attorney or
Yeah, I
anything else.
can't give you a day certain.
Oh, yeah.
Yeah, I mean, she's agreeable to try for it.
So-
But I can't give you a date certain as to when she'll have an answer.
Yeah, that's fine.
So what do you want to do? You want-
I guess we're on hold until the 20,
Well,
what,
this,
30th?
this evaluation says he's competent to proceed. That's what we're here for, isn't it? Competent-
No, Your Honor, this.
Nelson hearing?
Yes, Your Honor.
All right, well, so you're trying to get him on some mental health court, is that what you're trying to do?
and if we can wrap it up, there's no reason to ask for another attorney.
We can wrap it up.
And as I've indicated to him, but I can't provide him with a date certain.
What do you say, Ms. Gleason?
Judge, at pretrial, this was asked of me about mental health court. This involves threats to the governor and the CFO of Florida, so there's a lot of hoops that I have to go through to even propose this resolution. I told Ms. Rivers that I would try to start working the contacts because it involves two very high-up officials to get approval, so we continued it to the next pretrial, October 30th, so that's what it's set for. There's also violation of probation cases, so I just have to speak with a lot of people. This was just asked of me.
All right,
Monday, so
well,
it'll take a
that
little
has
time.
that has nothing, Miss Rivers can't make them.
No, I
speak
understand
up.
that. I understand that.
All right, well, she's effective.
Yeah.
We're gonna leave it
There's
to-
no, if there's a possibility we can get this all wrapped up by the 30th of October, I don't need another attorney.
Whether she can get it wrapped up or not doesn't mean anything about whether you get to have another attorney or not.
Oh, I understand that, but,
I need to find she's ineffective, and it sounds like she's effective because she's trying her best to get you in mental
well,
health court.
what happened was, Ms. Rivers said that 60 or 90 days ago, that we were looking at probation or mental health court. They were open to mental health court. Then I was told that it was nothing on the table but prison alone, and there were just some variations, and
Well,
I had
mean,
some
she's-
concerns that she also worked for the district attorney's office at one time, and the victims are both the governor and the CFO, which pay Ms. Rivers and pay the district attorney's office. So
She's doing the best she can.
that's what I understand, and that's pretty
she's
much where I'm at
effective.
right now. I'm
And,
ready to, I believe, I don't have a problem if we can get some mental health court, and,
Well, if you can't, doesn't mean she's ineffective, okay?
okay.
So,
Yeah.
you have every right to have another hearing if that's what you think.
Yeah, I'm just not, I wasn't prepared for that. I didn't even know I had a court date today, and I don't have any
The reason you have a
paperwork.
court date is Ms. Rivers is
Yeah.
trying very hard to get your case dealt with. Okay?
Okay.
So October, what we got him, October 30th?
Yes, Your
Yes, Your
Honor.
Honor.
Is that enough time, Ms. Glisson, you think?
Actually,
Probably-
since this is a VOP, Your Honor, can we just put all the cases on the November 2nd miscellaneous?
Yeah, November 2nd. Give you a little bit extra time.
Thank you.
And as soon as you find out something, let Ms. Rivers know so she can.
Absolutely.
She's usually good about
I sure
that.
will.
All right, thank you.
Everyone's got people they've got to go, who.
Oh, yeah, absolutely, absolutely.
Okay, thank you, sir.
Thank you.
Thank you. Thank you.
Your Honor, I spoke to Mr. Cash from just a few minutes ago and explained what the state's offer is to extend his probation and maintain that withhold so he won't be a convicted felon. I believe he wants to accept that offer to extend his probation for 6 months.
Okay. Come on up.
So,
All right.
Judge, I think with admitting the violation that he hadn't completed everything he needed to complete, we can extend his probation for 1 year, or 6 months, 6 months, maintain his withhold, and assess the $100 cost of prosecution, and I suppose now the $150 public defender fee.
All right, this is 22 CF 1548, State versus Gregory Dale Cash. And he is here for a violation of probation, correct?
Yes, Judge.
Mr. Cash, would you raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God. You want to admit that you violated probation? Has anyone forced you or threatened you to enter this admission?
No, sir.
You understand the rights you're waiving by entering this admission?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing?
No, sir.
Are you happy with the work your attorney, Mr. Gibbs, has done for you?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it and imposes, still withholds adjudication, extends probation by 6 months, $150 PD fee, and is it $50 cost of prosecution?
$100 cost of prosecution.
$100 cost of prosecution. So your probation is extended by 6 months.
And complete original requirements, Judge.
Complete original requirements and withhold adjudication. That's
If-
whether, I don't know what you're on probation for, but whether it affects any rights like having a gun or all that, I don't know. But I'm withholding adjudication.
The standard,
In other words, I'm keeping everything the same as it was, it's just 6 months longer.
Right, that's what I was trying to understand.
Okay, no problem.
I believe the standard condition is that he can't possess firearms while he's on probation, but afterwards he would be able to possess, so long as he's not a convicted felon.
All right, well, as far as what I just did, I haven't changed you to a conviction felon on this case. I don't know what other cases you got, okay?
Okay, thank you.
Okay, thank you.
Thank you, Judge.
And Your Honor, since he's only got 6 months to do this, to keep us from turning around and doing a VOP for him not paying the monies, if we could just go ahead and put on the record now, if he has any outstanding monies at the time of his termination date, they are to go to collections.
Yeah,
And that'd
we'll
take
go to
care of that.
collection.
Okay, thank you, Your Honor.
We'd request to waive cost of supervision if it hasn't already.
Yes,
Thank you, Judge.
and
I believe that's all I have unless the clerk has something else for us. Agana?
Your Honor, if I may readdress Cordero Roberts, it was number 33 on the 130 docket. I had indicated to you that I had spoken to him by phone. I thought he was in the area of the hurricane. I couldn't understand why he wasn't here. Apparently, my assistant had filed a waiver of appearance for him today. She did, so it's not that he failed to appear. We had filed a waiver of appearance, so I missed that. I spoke with the state, and she is okay with if we put this on for October 30th for him to come in and resolve it on that
did I
day.
have a capias issued for him?
No, you had continued it to 9/7.
All right. And that waiver was at your direction, correct?
Yes, sir.
Okay. What else? What else y'all want to do?